You haven't requested to take it?
I didn't know I had to.
So you don't think you need to?
I didn't know I had to, but
So you don't think you need to?
well, I probably do, but I know that I've been, I have no desire for any sexual activity. I prayed to God that He'd take that away from me. And so ever since then, I've had no desire for any sex. So I just prayed He'd take it away from me, and so I can't even watch this stuff on TV. Anything on TV like that, I just don't even, just turn away, you know.
I don't have any other questions.
Now, this might be hilarious if we weren't talking about one of the worst roaches, the worst chomos that we have ever covered on this channel. We are talking about a monster who was doing this to his autistic son from the age of 8 until the age of 14 when he was finally caught. And yet a judge allowed him to take a plea deal that would wipe out other felony charges that would have set him up for a life sentence. Instead, he gets just 20 years.
All right, Mr. Foster, good afternoon, sir.
That's me.
Introduce yourself. Tell us your name and DOC
My
number.
name is Douglas Foster.
And what's your DOC number?
It's 536-885.
Let me see. Yeah, I was looking at your SIG. Yes, 536-885. Thank you, sir. So, Mr. Foster, you're classified as a first felony offender. You are currently serving a 20-year sentence, sentenced in Ouachita Parish in August of 2008 for one count of aggravated incest. Parole eligibility is August 15th of this year. You don't earn good time, so your full term date is going to be August 14th of 2028. Does all that sound accurate to you?
Yes, ma'am.
All right. Well, your case has been assigned to Mrs. Ledoux. Before I turn it over to her, I'm going to ask Warden Thompson, is there anything you can tell us about Mr. Foster?
No, ma'am, no comment.
All right. Ms. Ledoux.
Tell me why you're here and why you think we should allow you to get out today.
The reason I'm here is because of incest, and I had possession of marijuana, and I had 2 illegal guns, you know. And that was the only thing they charged me with.
Okay, have you taken sex offender treatment yet?
No, ma'am, I was supposed to in Winfield, but they shut down. I was working as a tutor, so I never got a chance to get around to taking it, and they finally shut the place down.
How long have you been there?
I was there 12 years.
How long have you been at the
I've been
facility?
here, almost 2 years now.
And have you requested to take it?
No, ma'am.
You haven't. You haven't requested to take it?
I didn't know I had to.
So you don't think you need to?
I didn't know I had to, but
So you don't think you need to?
well, I probably do, but I know that I've been, I have no desire for any sexual activity. I prayed to God that He'd take that away from me, and so ever since then, I've had no desire for any sex. So I just prayed He'd take it away from me, and so I can't even watch this stuff on TV. Anything on TV like that, I just don't even, just turn away, you know.
I don't have any other questions.
Have you done any victim awareness training?
They supposed to put me in a class, but I haven't done it yet. They haven't put me in the class yet.
Yeah, all right.
That's one thing I do need to take.
Yeah, you had a significant impact on the victim. I think we're prepared to vote, Mr. Foster, Mrs. Ledoux.
I don't see any, sex offender treatment, no victim awareness. No- I just don't believe that you're prepared, to be a successful, member of society without some of that treatment. My vote is to deny.
Mr. Bauer.
I concur, deny for the same reason.
Mr. Foster, my vote today is also to deny. You're not prepared for release. We also had extensive opposition in the record from the sentencing judge, the district attorney, and law enforcement. So you've got some work to do, Mr. Foster. Today, your parole is being denied.
They are as disgusted about this roach as we are, I think, and we're about to go see another parole hearing of another roach, another insane injustice of Louisiana. And here's what I mean by that. And here's what I'm going to do. I'm going to review the appeal that this roach filed. And thankfully, he filed it because we can go into the details of just how vile his crime was. Not just how vile his crime was, but how incompetent I guess the DA was with prosecuting this case, and then also how handicapped the judge is by the legislation in Louisiana around people like this who commit these kind of crimes. You see, because in a nutshell, what happened was his 14-year-old autistic son told someone what his father was doing to him. So they raid the home, and inside the home, they find videotapes of him doing it to his son for years. They find illegal weapons and illegal narcotics. They file all of these charges, indictments against him for the guns, for the narcotics, for possession with intent to distribute. They had a lot on him, right? And then he went to trial. And then after the first day of trial, so he put ready the state through the costs of preparing for the trial, picking the jury, all that goes into it. And then at the first day of the trial, he said, "Wow, this doesn't look good for me. I'll take the plea deal." And what they do is they agree to drop all the other charges and get him just one count of aggravated, the I word. And then the judge, by Louisiana legislation, could only give him this 20-year sentence. Now, the judge in reality could have given him a 25-year sentence had they taken a different plea deal, but the plea deal that they took was that he was above the age of 13, which wasn't true. So now the mandatory was down to 20 years because Louisiana law actually states that if you commit this type of crime against your son or daughter who's 13 years old, the maximum a judge can give is 20 years. I mean, think about that. That's baked into the law. That no matter how vile the crime, that's all the judge can do. They don't want you to give 21 years. They don't want you to give 25 or 40 or 50. How insane is that? I mean, I want to sit across from a legislator, from those in charge, and say, "Can you explain this to me like explain this simply like I'm an autistic 8-year-old boy? Why it is that you can't give this monster more than 20 years?" But and again, we're going to jump into another hearing after this, so we'll try to do this, succinctly. But let me share my screen. On August 20th, Sergeant Joe Baugh of the Ouachita Parish Sheriff's Office received a videotape of a 14-year-old juvenile, which was made at the Children's Advocacy Center, wherein JF stated that his father, Douglas E. Foster, had been essaying him since 2001. Keep in mind, this is in 2007. 6 years. Thank you, by the way, for the DA showing up to this case. Pathetic. And again, the bottom line is he's getting out in 3 years no matter what, or 2 years no matter what. He's walking the street. Now, JF has Asperger's syndrome with high functioning condition found on the autistic scale. JF stated that his father, JF, made him perform on him, and that his father performed on him as well. The defendant also forced JF to watch videos and look at magazines with him, and forced JF to watch him stimulate himself with an electric toothbrush. In addition, the defendant took pictures of him. They could have gone him just for that. Just for that. But no, they didn't bring those charges. They didn't bring creating PC or just images. They didn't because they're weak. In his living room with a black cowboy hat over his face. Wow. JF indicates that the picture his father took of him lying naked on the couch would not print. JF stated that his father had a bunk bed for him to sleep in when he came to visit, but the upper bunk was always stacked with possessions, and then he had to sleep in the lower bunk with his father. JF also stated that his father instructed him not to tell anyone about the activity because it revealed what was going on, and that he would go to jail. On August 21st, 2007, the parish deputies obtained a search warrant, which is good for them. August 21st, they got the warrant, and it was August 20th that it was reported. So one day. And went to the defendant's home in Monroe, Louisiana. When the defendant came to the door, officers immediately noticed a strong odor of the devil's lettuce. A search of the premises produced many weapons found within the feet of the devil's lettuce, videos, VHS tapes, magazines, and a box of homemade and store-bought toys. Cameras were located in the living room and were seized by officers, as was a cowboy hat located in one of the rooms. The defendant was arrested and read his Miranda rights. Federal charges were filed against him in possession for the weapons. And we just covered a parole hearing, by the way, recently. It's in the Return of playlist, where this man was a low-level dealer. Low-level dealer. His third offense, he was caught with like $400 worth of narcotics, and that's the state saying it was $400 worth. I believe they exaggerate. Why not? And he got a federal charge for having a weapon, and he's serving 50 years in Louisiana State Prison. He was sentenced 150, but he was allowed to serve them at the same time, so a total of 50. And when he gets out of the 50, he's got 6 years in feds. They prosecuted him to the fullest on those charges, but this man, no, just a plea deal. Further, he said that JF had been seen and watching videos denied he made JF. He admitted that he attempted to take pictures of JF while wearing a cowboy hat and a towel, but stated that the battery died. Okay, sure. He also admitted to taking his son's medications so that it would make him extra aroused. Wow. On September 21st, 2007, he filed a charging defendant aggravated incest, and August 1st, 2001, August 31st, 2007, inclusive, blah, 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 indecent behavior juvenile, pornography and violation, possession with intent to distribute. So they must have found scales or something to get that one, right? August 21st, 2007, and the case scheduled for trial. So they had all those. They did the right thing, right? They got him with indecent, with aggravated, with creating images, possession with intent to distribute. So they're ready to throw the book at him. Now, the case was scheduled for trial April 21st, 2008, and a jury was selected and sworn. They go through all the costs of doing that. After hearing the testimony of Sergeant Baugh, the defendant then decided, you know what, maybe I'll plead guilty to aggravated, right, with a victim greater than 13. And here's the thing, he was obviously younger than 13, but they agreed to this deal. They're holding the royal flush. They went through the cost of a trial. They have image. They have everything. And not only did they let him to agree to plead to just one count, but they now make him older than what he was, which buys him 5 years because the judge can only sentence him to 20 instead of 25. It's barbaric. The other 3 charges against him were dismissed. A PSI was ordered and returned by August 10th, 2008. August 22nd, 2008, the trial judge examined the PSI report, allowed a statement by the victim's grandfather, allowed the defendant to speak on his own behalf, and then thoroughly examined the sentencing factors. And the trial judge found the defendant to be one of the worst offenders. And again, this isn't necessarily the judge's fault. I mean, we have seen cases where judges will say, no, I'm not going to let you take a plea. And in that sense, I think it's the judge's fault. Maybe the judge wanted to spare his son taking the stand. But the problem I have with that is that in 20 years, he's gone, he's out. And that's it. 20 years go by fast. He's going to be out in a couple of years. And as we can see, he's learned so much. Jesus has now gotten him not to think about stuff like this anymore, right? Also noted by the defendant had been spared what amount of life sentence by his attorney's action having the other 3 crimes dismissed. It would have been a life sentence and it should have been a life sentence. Previously stated the trial judge sentenced him to 20 years. The judge, that was it. Once the judge accepted this plea deal, the maximum the judge could sentence him was 20 years, according to Louisiana legislation. Think about that. It makes no sense. Who writes these laws? He contends that he did not have significant criminal record. In fact, his prior conviction, misdemeanor conviction of possession in 1978, he's elderly parents with a catfish farm. Yeah, I need to help the catfish. And, you know, he loses his appeal. I'll put the link in the description. Thank you, Lady Holly. Thank you, Sir Richard. But it's, see, this is, he can't, this is right here in the legislation. He cannot serve more than 20 years. And as little as 5, by the way. So that's it. That's it. That's how insane it is. That's true madness. And now we're going to go watch this next hearing. And I do want to give a shout out to, you know, it's spelled Mitchell. So is it Mitchell or Michelle? But thank you for emailing me and saying, hey, Mandoo, check out this case. It happened to be that Lady Holly pointed out the case. I had recorded it, but forgot to upload it. So if she had not, or he had not written me, it would have been lost in my hard drive. And we're going to go see it now together. So with that, let's jump.
All right, good morning. The Committee on Parole is reconvening. We're at Morehouse Parish Jail Annex. It is 10:54 on June 10th, 2025. Good morning. Would the officer in the room please introduce yourself for the record, please?
Good morning, ma'am. My name is Warden Quentin Douglas.
All right, Warden Douglas, thanks for accommodating us today. We appreciate it. I know you have a lot going on today, so.
Yes, ma'am.
All right, Mr. Lynn, would you introduce yourself? Tell us your name and DOC number.
Jerry Lynn, 633060.
All right, Mr. Lynn, let me read some identifying information into the record. You're classified as a first felony offender. You have a sentencing date there in Morehouse Parish, May 21st, 2015, for carnal knowledge of a juvenile and indecent behavior with a juvenile. You received a 10-year and 5-year sentence. Those are running consecutively, so you're serving a 15-year sentence. And your parole eligibility date was November 21st, 2018. You don't earn good time, so your full-term date is May 25th, 2027. Is that information correct, sir?
I believe it is, yes.
All right. Mr. Land, your case this morning has been assigned to Mrs. Stapleton, so I'm going to turn it over to her so she can hear from the warden and take your statement and start our interview. Mrs. Stapleton.
Okay, Mr. Land, I'm going to ask you, what happened that caused all these charges? There was a date that this child came to visit you. I want you to start from that and tell me what happened.
Oh, that's been a while back. What it just basically comes down to is I just took a notion and lost my mind. It just happened.
All right. Well, this child, she was your stepdaughter, correct?
Well, not legally, it was my wife's, current wife's, daughter, yes.
I'd make her your stepdaughter.
Okay.
That she had known you from the age of 2. And then this happened when she was 14 or 15 years old.
I want to say she was 15.
Okay. So she had a bond with you, a trusted bond. You were her father figure.
Right.
Mm-hmm. So she came to visit you, and during that visit, there was 3 times that the girls came to visit you, but on one particular occasion, you gave her a marijuana cigarette to smoke and vodka to drink. Is that correct?
That's correct.
Yes. And then from that, we had the aggravated rape.
Okay,
Is that correct?
well, that's the first time I've heard that.
Oh, well, how did that happen? And not going into details, but there was 3 aggravated rapes you were charged with.
I don't recall seeing any of that on my rap sheet, or I didn't hear any of that in my discovery or sentencing or anything.
Did you have sexual intercourse with this child? Are you saying you did?
I did.
Did, okay. Was it on a camping trip?
Was it on what?
Y'all were on a camping trip? A
Yes.
visit? Yes,
Yes.
that's the time I'm talking about. So yes, it did happen.
Right.
All right, and then when you were interviewed, you victim blamed the child. You said she came on to you and you weren't going to turn it down. But now this is after you gave her vodka and a marijuana cigarette, which was illegal too, because, you're not supposed to give children vodka and a marijuana cigarette. So get them drunk, and then this happened and you were her father.
Right.
Okay, so from that, we come forward with, you were eventually charged with, let's see, the 3 counts of aggravated incest, but 15 counts of indecent behavior, 7 counts of carnal knowledge, and all of that was pled down to 1 count of carnal knowledge of a juvenile, and you were sentenced to 10 years. And then another one count, and there was 15 counts of indecent behavior with a juvenile, and that was pled down to 1 count, and you were sentenced to 5 years, and that ran consecutively, so a total of 15 years. Is that correct?
That's correct.
Okay. So with all of that said, have you taken the sex offender class?
I had started it, but they had discontinued it at Winfield during my right after my first phase of it.
Where you're at right now, they don't have sex offender class?
No, ma'am.
No, they do not. Okay. Any other classes that you've taken?
No, ma'am. I had become a tutor at Winfield, and that is just about it.
You've appealed this case once, is that correct?
I did.
You did. Okay. Well, just a little bit of what the court said about that, because, they denied your appeal. The court noted that as a result of the defendant's action, the young teenager will carry the emotional scars for the rest of her life and will require counseling for most, if not all of her life. The court noted that the defendant received the benefit of leniency through the plea agreement, which resulted in the dismissal of 20 additional criminal charges. The court stated the defendant used his position and status as the victim's ex-stepfather to facilitate the commission of the offense, as he had known the victim since she was 2 years old and developed a close relationship with her, and then violated that trust, and that you attempted to blame the victim, which is what I was talking about. Do you have anything to say about any of that? Is that all true?
That's all true.
Okay, you have strong opposition from the AG's office, the DA's office, the sheriff's department, and the chief of police. And you have past victim opposition. I noticed that you don't have, if you were to get out, I didn't see a residential plan or an employment plan. Was that correct?
I don't have anything as of yet.
Yeah. And then we just talked about you haven't had any sex offender classes, which in 2018, they were talking about that as a reason for denial. Okay, I'll turn it over to my colleagues if they've got any questions.
Mr. Farrar, any question?
Good question.
Warden Douglas, is there anything you can tell us about Mr. Lynn?
As far as I'm concerned, just strictly knowing him since I've been employed here, he's one of our trustees. He does the washing of clothes and everything for the annex. He's prompt, on time, does his job every day, and doesn't cause any problems. Respectful, speaks to everybody properly, and basically, if you didn't know he was there, you wouldn't know he was there.
Thank you, sir. That's good to hear. Mr. Lynn, anything else you want to close it out with? Anything that you'd like to say?
Well, the events that we're talking about are in the past. It won't happen again. I can guarantee you that. There's, I'm sorry that I ever stooped that low. I was at a low point in my life. And that would probably never happen again. There's no possible way.
I'm glad to hear that. Thank you, sir. I don't see any other questions, Mr. Lynn. I think we're prepared to vote. Mrs. Baker?
Mr. Lynn, today I'm going to deny your request for parole, and it's because of the heinous nature of the crime to a juvenile, the extensive opposition of law enforcement, all law enforcement, and victims' opposition.
Mr. Barra?
I concur with Mr. Stapleton for the same reason.
Mr. Lynn, my vote today also is to deny, really for the same reason you were denied at your last hearing, because you haven't had the sex offender treatment. I think you would, it's a public safety issue that you received that treatment. I realize you've not been in a place that offers it, but based on the same, that and the same reasons as quoted by Mrs. Stapleton, my vote today is to deny. So today, sir, your parole has been denied. Good luck to you, sir.
Okay. Thank you.
That concludes our business for the day. We're going to adjourn. It's 11:05.
Did you guys catch that? How he said that would probably never happen again. It's not the first time we have heard chomos, roaches say that, not even being able at their own parole hearing to state that it wouldn't happen again. I don't know. Do you give them brownie points for at least being honest? Or is it more like a Freudian slip and they don't even mean it? But look, let's it's like you see them one, you see them all. Just absolute insanity, a monster, a roach, right? So let's look at Lady Holly's info. We actually have the appeal, so we'll go over the details of the case. So originally charged with 10 counts of criminal knowledge. Okay, so here's like the fact. Let's just go to the appeal. Thank you, Lady Holly, but we'll pull it up here. She provides to us. So here it is. The victim in this case resides in Arkansas with her mother and her half-sister, the defendant's biological child. So he does this to his biological daughter's sister. The defendant and the children's mother divorced in the fall of 2012. On several occasions during the summer of 2013, LS and L traveled to the defendant's house in Morehouse Parish for visitation for the children. On October 15th, 2013, a detective with the police department of Little Rock, Arkansas, contacted Morehouse Parish Sheriff's Office. The detective stated that he received a complaint through Arkansas State Police Crime Against Children Hotline. The detective informed the Morehouse Parish Sheriff's Office that LS, who was then 15 years old, had possibly been by the defendant's, her former stepfather. So I think he was honest about the age. I guess we don't really know when it started, but and you see how he tried to play it off. I wasn't her stepfather technically at the time. Arkansas authorities interviewed LS, who revealed that she and the defendant had engaged in intercourse on 3 different occasions between June and August of 2013. LS provided detailed description of series of intercourse encounters with the defendant. She also stated that the defendant provided her with an alcoholic beverage on 1 occasion, and that she and the defendant had a marijuana cigarette, as Ms. Stapleton calls it. Described, it's kind of like tell us your age without telling us your age when you say marijuana cigarette. I love it. It's endearing. Inciting. I love Miss Stapleton. I'm not. I hope you guys don't take that the wrong way. Incite during which the defendant held a knife. Okay. So now let's come back home to this. So she described one incident during which the defendant held a knife to her neck and stated, "This is going to be kinky. And if you don't do what I tell you to, I'm going to cut you a little bit on your neck." In response to the information provided on the official Arkansas deputy from Morehouse Parish located in the defendant and arranged interview. During the interview, the defendant stated that LS and EL visited him in Arkansas once a month during the summer of 2013. He admitted that during one visit, he and Ellis had marijuana and drank vodka. Can you imagine that mom gets divorced and what he does with his once a month visitation is this? And again, it just goes to, I do believe that he picked this woman, married this woman to gain access to his prey. Like, I don't think it's a coincidence. And meanwhile, this poor woman thinks, wow, he's a great guy. He cares. He has a daughter, my daughter's age. They can be sisters. And meanwhile, the whole time, he just has one goal in mind. And I believe that. The defendant stated that Ellis initiated sexual contact with him by rubbing up against me and kissing me. I didn't resist. He further stated that he had sexual intercourse with LS and that they performed oral on each other. The defendant denied ever holding a knife to Ellis's neck. Thereafter, the law enforcement officers conducted a search on Ellis's phone. The search revealed that the defendant and Ellis began exchanging photographs and text messages September of 2013. After Ellis returned from Arkansas, the officers discovered that the defendant had sent Ellis explicit text messages and several photographs of his erect thing. The search also revealed that the defendant had solicited and received numerous photographs of Ellis. The defendant admitted that he sent inappropriate text messages. So here's, again, the two-facedness of the DA, because they did get him for 15 years, but just on the photos alone, let's just do a quick search if you're curious. Again, this happened in 2016 was the appeal. So let's just say 20. All right, well, you're right. We know when it happened, 2013. So let's just do a quick search. In Louisiana in 2013, what was the legislation prison sentence someone could get for creating and distributing, because I think it is distributing CP. I'm just putting it in my AI. I use Grok because I'm always on, X anyway. So I'm just, okay. So in 2013, I could share this screen, right? There's nothing. Yeah. Those of you who want to give me a follow on X, go ahead, or Instagram. We reached 30,000 followers on Instagram just the other day. It's pretty cool. Basically on Instagram, I just post like shorts, kind of like what you'll see on YouTube, but I post there every day. And I put description too, with the case, with help from Grok with the descriptions. Where does it show? Okay, conclusion. In 2013, Louisiana imposed 5 to 20 years imprisonment for creating or distributing CP with enhancement of 25 to life if the victim is under 13. So 5 to 20 is what they could have given him just for that. Just for that. Not the actual essay, not the contributing to, not the whole, right? Just for that. And what does the DA have? They have the royal flush. They have forensic evidence. They have proof that he did it. And they give him a plea deal of 15 years. This is where the two-faced DA are just full of themselves. This would have been so easy. I just had to point that out. It's really weird. It's just weird. The victim in this case resides. Okay, where were we? We were down here. Okay, we're here. As stated above, the defendant was charged with 7 counts of felony criminal knowledge of a juvenile in violation. In subsequent proceedings, he was charged with 15 counts of indecent behavior. February 3rd, 2015, pursuant to the plea agreement, the defendant pled guilty to 1 count of felony criminal knowledge of a juvenile, 1 count of indecent behavior with a juvenile. In exchange for the defendant's guilty plea, the state agreed to dismiss the remaining 20 counts. There was no agreement to sentencing. Following the sentencing hearing, the trial court sentenced the defendant to serve 10 years at hard labor for the criminal knowledge and 5 years at hard labor for the indecent behavior of juvenile. I love the hard labor part. It's such, it's like, what's your hard labor? Just sit in jail and read books all day? The court ordered the sentences to be served consecutively. Subsequently, the defense filed a motion to reconsider. And he did get a deal of a century, didn't he? But it just goes to show, and how old is he? So you look at Lady Holly's info, she always gets it right here and does not show any personal information. So no birthday. Thank you, Lady Holly. See, we follow YouTube guidelines. Age 60. So he's going to be getting out anyways. When is his full term? We missed it. I mean, I know they mentioned it, and he had a parole hearing in 2018 before we started covering, but I guess he's getting out. What was it? Somewhere in like a few years, right? 3 years or 5 years. Fact of the day. There are hundreds of kilometers of bookshelves in the Library of Congress. Book lovers, welcome to Utopia. The Library of Congress has around 1,348 kilometers of bookshelves with more than 39 million books. That's long enough to stretch all the way from Chicago to Houston. It's totally random. I wonder how many of those books are worth reading. And there you have it. He will get out. And don't worry, he gave us his word that he probably won't do it again. I think he'll be probably 65 when he gets out or younger. That's a lot of years to reoffend. Kind of scary, if you ask me. But there it is. And with that, I'll let you go.
And I don't know that he can get better. But letting him out now doesn't help he or me and my children's situation. I had a daughter that was full of life. Now she doesn't come out of her bedroom except to go to school. To date, we seek many, many hours of treatment for this.